Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
Matter of M.S. Erie, County Department of Social Services, decided February 17, 2026. Opinion. Wilson, Chief Judge. Appellant M.H. has a daughter, M.S., and a son, G.H. Family court found that she abused M.S. and derivatively abused G.H. The court's findings were entirely based on videos that appeared to show M.H.'s former live-in boyfriend, D.K., sexually abusing M.S. Family court determined that M.H. had abused both her children by failing to protect them from D.K. Because the foundation offered for the videos was insufficient, we hold that family court erred in admitting the videos into evidence, and therefore reverse. 1. In February 2022, Erie County filed concurrent family court Article 10 petitions against M.H. and D.K., alleging they had abused both children. In 3 videos bearing timestamps showing dates in May, June, and July 2019, D.K. appears to be engaged in sexual contact with M.S. on the couch in the living room. M.S. was 14 in 2019. In one of the 3 videos, M.H. can be seen leaving the room a few minutes before D.K. is shown touching and caressing M.S. The videos were not discovered in the family home or on any camera or computer belonging to D.K. or M.H. Instead, in the course of an FBI investigation into persons suspected of trading child pornography, the agents executed a search warrant on B.W., who lived in Syracuse. In the course of questioning by FBI agent Martin Baranski, B.W., though not under oath or in any sworn statement, said, according to Agent Baranski's recollection, that he had been hacking into security web cameras for the past few years. B.W. further stated that in 2019 he had hacked into a security camera which showed what he thought was an adult male sexually abusing the man's 15-year-old stepdaughter. B.W. claimed that he watched a lot of the security camera footage of this house and saw a lot of interactions between the individuals depicted in the videos. He told Agent Baranski he had saved some videos from that camera in a particular location on his computer, along with a screenshot that contained details about the security camera login information, including a possible name, email, and IP address. Searching a digital copy of B.W.'s computer, Agent Baranski found 3 videos that appeared to show an adult male sexually abusing a young girl. The videos contain timestamps indicating they were recorded around the summer of 2019. Based on information from the screenshot on the suspect's computer and other investigative work, Agent Baranski was able to identify D.K.'s name and workplace. He then relayed that information to New York law enforcement. After attempting to match photographs of D.K. and M.S. to people shown in the videos, state police called M.H. and told her they wanted to speak to her regarding her daughter with some internet usage. They met with her in person and provided her with screenshots of 2 people taken from the videos. M.H. told police that the screenshots depicted D.K. and M.S. After accompanying M.H. to her home, police then informed M.H. that the videos appeared to show D.K. sexually abusing M.S., and M.H. gave consent to search her home and take photographs. Police then searched the home, took photographs, and spoke to M.S. They asked M.H. to take M.S. and G.H. to the Children's Advocacy Center for interviews. During the interviews, M.S. denied that she had any sexual contact with D.K. M.S. said she was conflicted and confused by the allegations and description of the video. And, after being asked whether anyone had ever touched her, with or without her consent, M.S. said that had not occurred. G.H., who was 12 at the time of the interview, did not seem to know anything about why he was being interviewed. GH denied that he had ever been touched inappropriately or that his sister had ever confided in him that someone had hurt her. That same day, during a consensual search of the family's home, police officers took several pictures of the living room which appeared to match details shown in the videos. Although, pursuant to search warrants, the police obtained DK's computers, both work and home, and cameras, no evidence from those devices was offered at trial. On Erie County's motion, the children were removed from MH and placed with their maternal grandparents, and a stay-away order was issued directing that DK have no contact with the children. By the time of the dispositional hearing in November 2022, the children had been placed in a non-kinship foster home. During the pendency of these proceedings, MS turned 18 and aged out of foster care. GH, who is now 16, remains in foster care. At the hearing, neither MH nor DK testified, but MH joined DK's objection to admitting the videos. MS and GH each was separately represented by counsel. Neither child testified. Erie County's sole evidence of abuse was the videos obtained from BW. Erie County attempted to lay the foundation for the videos through the testimony of Agent Baranski and Gary Mahoney, one of the state police officers who searched the home. Agent Baranski testified as to how he came to find the videos and his delivery of the videos to the New York State Police. Investigator Mahoney testified that the living room he saw at the house matched the living room in the video, and noted that he observed cameras in the house, and in MH and DK's bedroom there were sex toys of the kind depicted in the videos. He identified MS and DK in screenshots taken from the videos. Based on Agent Baranski's chain of custody testimony, Investigator Mahoney's personal observations of the location depicted in the video, and MH's identification of DK and MS in screenshots taken from the videos, family court held that Erie County had laid a sufficient foundation to admit the videos. Crediting the technical experience and expertise of Agent Baranski, family court held that his testimony indicated there were no signs that the videos had been manipulated or altered. In its order of fact-finding, family court gave great weight to the videos in both proceedings, and determined that both MH and DK had abused MS and, in MH's case, derivatively abused GH. By the time of the dispositional hearing, it was undisputed that MH had completed a parenting class, obtained suitable income and housing, and moved out of DK's home into her own residence. At the hearing, the court issued a stay-away order of protection against DK in favor of both children. Over the objection of MH and of both children, who both asked to be returned to MH's care, and 5 days before MS's 18th birthday, family court also ordered both children to be placed in foster care, and that MH have only agency-supervised visits with them. Upon turning 18 5 days later, MS aged out of foster care and moved in with a family friend. A later dispositional order set out the conditions with which MH had to comply to have her son returned to her care. On appeal, MH argued that 1. An insufficient foundation had been laid to admit the videos. 2. The finding of abuse against her was not supported by a preponderance of the evidence. 3. The facts supporting the abuse finding as to MS could not sustain a finding of derivative abuse against MH with respect to GH. And 4. The dispositional order setting the conditions for GH's return to her pair was not in GH's best interests. The Appellate Division affirmed, with Presiding Justice Whalen in dissent. The court held that any uncertainty with respect to the videos went to the weight, not admissibility, of the evidence. As to the abuse and derivative abuse findings, the court held that family court could infer from the evidence that the mother knew or should have known about the abuse and did nothing to prevent it. and that the facts surrounding M.S.'s abuse were so closely connected with the care of G.H. so as to justify the finding of derivative abuse. The court held there was record support for family court's dispositional order as to G.H. We granted leave to appeal. 2. On appeal to our court, M.H. raises the 4 issues identified by the dissent below. 1. Family court erred in admitting the videos because they were not properly authenticated. 2. The finding of abuse against her was improper because, in her view, actual knowledge is required to sustain a finding of abuse under Family Court Act, Section 1012E3A. 3. Family court's finding of derivative abuse as to G.H. was improper because there was no evidence that any sexual abuse was ever directed at G.H., and he did not meet the statutory definition of an abused child. And 4. The dispositional order placing G.H. in foster care and setting conditions for his return to M.H. was not in his best interests. Because we agree the videos were not properly authenticated and therefore should not have been received into evidence, we have no reason to reach the other issues M.H. raises. It is the burden of the party moving to introduce evidence to make a sufficient threshold showing of reliability. People v. Price. Reliability can be demonstrated by proof that the offered evidence is genuine and that there has been no tampering with it. People v. McGee. With respect to video evidence, we held in Patterson that a video may be authenticated through 1. Testimony of a witness to the recorded events, or of an operator or installer or maintainer of the equipment, that the videotape accurately represents the subject matter depicted, or 2. Testimony, expert or lay, establishing that the video truly and accurately represents what was before the camera. People v. Patterson. The authentication requirement applies to civil as well as criminal proceedings. See Zegarelli v. Hughes, applying Patterson's standard for authentication of videotape in civil context. Proper authentication of evidence vindicates the basic principle that evidence which is not what the proponent claims it to be can prove nothing at all. Price. In order for a piece of evidence to be of probative value, there must be proof that it is what its proponent says it is. Quoting United States v. Slicker. A comparison to the facts in Patterson shows why the videos here were not properly authenticated. In Patterson, the trial court admitted into evidence a surveillance video that purported to show a robbery inside a grocery store. People v. Patterson. Neither the parties who witnessed the crime or the store owner, who had died from unrelated causes before trial, testified as to the authenticity of the video. The police obtained the video directly from the store owner just 2 weeks after the crime and kept it secure in police custody, unaltered, until the trial. The trial court held the video was sufficiently authenticated by the testimony of officers who identified one of the defendants on the video and confirmed that the video accurately depicted the physical layout of the store, which he had personally photographed. Even so, we held that the video was not properly authenticated because of a lack of foundation and failure to provide a full chain of custody. Patterson. The foundation here is even more lacking than the one we held insufficient in Patterson. Whereas in Patterson, the store owner, who himself inserted the videotape into the store surveillance system, provided the video directly to the police, Patterson. Here, the person who allegedly created the videos, DK, provided no evidence or testimony, and BW, the child pornographer with no connection to the family who claimed to have hacked into DK's cameras, likewise never testified. Instead, Agent Baranski offered hearsay testimony as to what BW had told him. In Patterson, the unaltered feed of the footage from the grocery store was provided by the store owner. Here, there was no continuous video, only snippets excerpted from a longer, unrecovered feed of the camera by BW, who told Agent Baranski he had watched many days of video but did not explain what or how he selected and what he omitted or deleted. Agent Baranski did not testify that BW told him the videos were unaltered. The store owner in Patterson was a business person with no apparent ulterior motives. BW, in contrast, faced criminal prosecution at the time he provided the information leading to the discovery of the videos here, and had created the versions of the videos he delivered to the police by extracting them from a larger video or feed. Finally, the video in Patterson was obtained by the police 2 weeks after the crime. Patterson. Here, there was a roughly 2.5-year period between when the videos were stolen and snipped by the child pornographer and when they were recovered by the FBI. This long gap in the chain of custody of a key piece of evidence, 65 times as long as the gap in Patterson, raises further doubts about the authenticity of the videos. Our dissenting colleagues misinterpret the significance of our observations about BW's motivations and technical abilities. Those points are made to show the weakness of the authentication evidence proffered here when compared to Patterson, not to make any conclusion about whether the videos here are altered or not. One dissent describes the possibility that the videos in question were fabricated as ridiculous and outlandish, but the possibility that the shopkeeper in Patterson could have altered the videotape in question in the 2 weeks before delivering it to the police is even more remote. Regardless, the likelihood of the alteration is beside the point. The question at issue is whether the proponent of the evidence has done enough to establish its reliability. Here, the confluence of factors, including the bizarre circumstances surrounding the discovery of the videos and the long time period between their creation and their recovery, raise doubts about their authenticity, and the agency simply failed to carry its burden to dispel those doubts. Even if were we to bypass the authentication rules and ask instead the irrelevant and abstract question whether phony videos could be created by 2022 when the videos here were obtained by law enforcement, the technology to make realistic manipulated videos was widely available then. Even on its own terms, one dissent concedes that as of 2022, when law enforcement first took possession of the videos in this case, technological innovations enabled users to convincingly alter or substitute the appearance of people in videos of actual events. The facts relied on by Family Court do not alleviate the reliability concerns raised by the unusual origin and uncertain chain of custody of these videos. First, Family Court credited the expertise and testimony of Agent Baranski in determining the videos were not altered. Agent Baranski was conceitedly familiar with child pornography through his experience, but the county never sought to qualify him as an expert or establish his experience in video authentication, which is the point. Broad familiarity with a subject does not make someone learned in detecting evidence of tampering or fabrication. Yet Agent Baranski did not testify as to any training or experience in identifying signs of tampering or video alteration that could establish his ability to authenticate as a lay witness. He was not asked whether he examined the videos to look for tampering, whether he used any forensic tool to detect tampering, or even whether he was able to offer a learned affirmative opinion that the video was not tampered with as Patterson mandates. Instead, the question he was asked about tampering was, "Did you make any observations that led you to believe that the video footage had been tampered with or altered in any way?" To which he answered, "No," without elaboration. Agent Baranski himself may have possessed the experience or training necessary to authenticate the videos, but we will never know because he was not asked the important foundational questions. Investigator Mahoney's testimony that the videos matched his personal observations of the layout of the living room and items he observed there are similarly insufficient and are not meaningfully different from what we rejected in Patterson. There, an officer who had visited the store where the robbery occurred testified that the video was an accurate depiction of the store's actual physical layout. Patterson. The fact that much of the video apparently accurately depicted the home is not sufficient, as it was not in Patterson, to authenticate the video. If such testimony was insufficient then, the increasing prevalence of deepfake videos has only rendered the method of matching circumstantial details in a video to personal observations a more suspect form of authentication. Most fabricated videos leverage real details from real photos and videos of real places, then alter the pieces the person wishes to alter to create a realistic but manipulated video. In the authentication context, what matters most is whether the events depicted are as real as the proponent claims them to be, not whether there are some identifying features of the video that can be corroborated in real life. Contrary to the dissent's characterization that the circumstantial evidence offered here is insufficient does not mean that circumstantial evidence is never relevant to authentication. We see nothing short-sighted or troubling in continuing to rely on Patterson's proven framework in light of changing technological circumstances. Patterson, the obligation and need for responsible accuracy and careful reliability should not be sacrificed to some of the whims and weaknesses of fast-moving and rapidly changing technology. Without saying so, our dissenting colleagues would like to overrule Patterson. No party has asked us to do so, and Patterson is particularly prescient in the factors it identified as insufficient to establish the authenticity of a video, especially given the far greater ability to manipulate video images now as compared to 1999, when we decided Patterson. Erie County's reliance on People v. Goldman is entirely misplaced. In Goldman, we affirmed a trial court's authentication of a video posted on YouTube. The defendant, charged with a drive-by gang-related homicide, objected to authentication of a rap video appearing to show him boasting about the crime solely on the ground that the people could not prove when it was made. The cooperating witness, a friend of the defendant who was the driver of the car during the shooting, testified that the evening after the shooting, the defendant invited him to come to the filming of a rap video the next morning, and told him what the name of the video would be, which corresponded to its name on YouTube. The cooperating witness also testified that he viewed the video on YouTube shortly after defendant posted it, identified in the video the defendant and the two rear seat passengers who were well known to him, and identified the social media handle used by defendant and his crew, which appeared on the video. He further testified that the video introduced in court accurately represented the video he had previously watched on YouTube. Those facts provided a far more robust basis for authentication than is present here. The rules of evidence apply in family court just as much as they apply in any other court. The proponent of evidence bears the burden of demonstrating its authenticity. Patterson is on all fours with this case, and, as explained herein, the evidence establishing the authenticity of the store video in Patterson was stronger than that present here, yet we held that the store video was not properly authenticated. The failure to authenticate evidence sufficiently does not mean the evidence was false, but only that it was not properly authenticated according to the rules of evidence. Our dissenting colleagues' abundant use of colorful adjectives and adverbs neither establishes the authenticity of this evidence nor persuades as to the occurrence of the predicted catastrophes. We do not mean to suggest that the videos here could not have been authenticated, or that child victims must testify, or that BW, Agent Baranski, or some other person could not have offered adequate authentication testimony. But the evidence of authentication proffered here was legally insufficient. What that means for the next case is that in family court, as in all our courts, evidence must be properly authenticated. Accordingly, The orders of the Appellate Division should be reversed without costs and the petitions dismissed. Orders reversed without costs and petitions dismissed. Judges Rivera, Canataro, and Holligan concur. Judge Troutman dissents in an opinion in which Judges Garcia and Singas concur. Judge Singas in a separate dissenting opinion in which Judge Garcia concurs. Decided February 17, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.